All right, this is the Board of Building Standards meeting for July 25th, 2024. I am Amy Rivera, board member.
Ed Agus, board member.
Wayne Miller, board member.
Philip Motto, Boards Administration.
Jay Scaria, Department of License and Inspections.
Thomas Rybakowski, City of Philadelphia, License and Inspections.
Okay, our first case is for 3034 West Fontaine Street. Who is the applicant and are they here?
The appellant is Joanne
Good
Gamble,
afternoon.
and she's present in the room.
Joanne, I'm going to have to swear you in. Do you swear to tell the truth, the
Okay.
whole truth, and nothing but the truth?
Yes, I do.
Tom, or Phil, can you read it in?
Yes, this is MI 2024-004659 for the property located at 3034 West Fountain Street. Joanne Gamble is the appellant. She's present in the room.
Can we just make a clarification? Is it Fontaine or Fountain? Because I think our hearing list says Fountain, but I've seen it listed as Fontaine.
I have it listed as Fontaine. I'm sorry.
Okay.
Hey, let me gotta swear Tommy in too.
All right.
Thanks.
Tom, do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. All right. Tom, I'm going to let you take the lead.
Okay, so I have the property at 3034 West Fontaine Street had been declared eminently dangerous for structural deterioration of the property. The appellant in the room and filed an appeal. I believe the board does have a copy of that appeal filing, but the appeal basically states that the owner, Margaret and Joe, are now deceased as of May 28th of 2024. Prior to receipt of letter, we were not aware of the condition to make repairs. I am applying as her heir to death to attempt to make proper corrections to the home previously resided by family member. In the interest of time, I will go right to the photos of the property and then illustrate to the board and share my screen. So, sharing my screen now. Can everybody see my screen?
We can.
Okay, so this is the property at 3034 West Fontaine Street. You can see that the side load-bearing wall has suffered a partial collapse and that a tarp has been affixed over the side rear wall of the property or the side load-bearing wall, or what's left of in the area of the collapsed area. There's another photograph of that section of the property. Our assertion with the board, and I checked before today's proceedings, there is no permit application submitted with the department as of today. We are looking for a make-safe permit to be applied for within 10 business days. 10 business days would put the application to be required to be submitted into the department. I'm waiting for my calendar to open. We would be looking for a permit to be under review by August 8th.
It's Edie.
I
Ms. Gamble, do you have anything?
I only have one question for Ms. Gamble, and I need to just verify this property is not occupied, correct?
That is correct.
Okay. So yes, we would still stand by our representation to the board that we would be looking for a permit to be applied for no later than August 8th of 2024. With that, the department rests.
Ms. Gamble, would you like to tell us your side?
Yes, as stated with my my hardship, unfortunately, my mother passed away at the end of August. I'm sorry, the end of May. My father in 09, I want to say. To my knowledge, I knew nothing of the condition of the home. I was only notified by luck. A notice was sent to my home. I don't understand how that even happened with my parents' name, which notified me of the condition. Again, totally unaware of any of this. I got the notice on the day of repair, which was, I want to say 7/8. Immediately, I reached out to the office to inquire of any possibility of getting an extension to try to wrap my head around what to do and how to even rectify the problem if at all possible. I've hit a couple of brick walls in this short period of time. I did eventually make connection with what I am told is a licensed insured inspector and an engineer, because the supervisor, he did give me full details over the phone what I would need to do. I'm now waiting to try to get some further information from them, from the two individuals, in order to maybe help to rectify the problem. Again, I'm here today to try to ask for any possible extension to try to get these permits that I know are required. On top of that, again, the property is in the name of my parents. I'm also trying to work through some avenues to see what's possible or needed to do to even have my name placed on the property.
Tom, how does that work if she does not legally own the property, but yet she would have to be pulling the permit?
I have a will also,
Yeah.
and I was power of attorney prior to their deaths.
She would have to present that documentation and also go to the Register of Wills if she is probating the estate, but she would need to seek the advice of a real estate attorney to see how to probate that estate. But as far as the department is concerned, we allow 5 entities to apply for a permit. 1 is the owner, 2 is design professional, contractor, expediter, or attorney. So if the attorney is able to represent and she has the correct documentation, or thereas contractor and or expediter, we would accept that documentation and the permit submittal.
Do you mind if I ask a question? Ms. Gamble, just to clarify, powers of attorney, those no longer apply once the person's deceased. Yeah, just
I agree.
make that clear.
Yes.
But in the will, are you named as the executrix of the estate?
Yes, so I had one sister and she predeceased my mother, so yes.
Okay, so but you do not have you have not gone and been named the executrix yet. You still have to do that through the Register of Wills.
That is correct.
All right. Yes, I just I know that that's a little bit of a process, but I do encourage you to do that as soon as possible, because once you have the letters to be able to, or once you've been officially named, that'll enable you to do more things. So,
Okay, thank you.
Mm-hmm.
And you mentioned that you have gotten in contact with an engineer. Is there an inspection scheduled with them at this point?
Honestly, I just got a great contact. I want to say yesterday, well, the end of workday 2 days ago. So after sometime today, we have a meeting scheduled to try to get in and do, schedule an appointment.
Like the appointment's not scheduled yet?
I'm going to schedule that once today. Yeah, he advised me to communicate with you with this meeting today. Once
Okay.
we're done, I'm reaching out and we are going to schedule an appointment, hopefully within the next 24 to 48 hours.
Okay, are you local?
I am.
Yeah.
Was your mother living in this house? prior
No,
to the passing?
no.
I mean, hopefully, I mean, presumably the engineer will be able to identify what needs to be done in order to make the property safe. And that's not, fully, renovating the house or anything. But they would need to document something, and you would need to get, a proposal from, a contractor who's registered, certified by the city to do the work. And they would file for the permit. I guess, Tom, could the engineer, an engineer can apply for a permit as a design professional, I would assume. But obviously, if it takes longer, I'm just thinking logistically, if it takes longer to get a contractor on board, but a permit is applied for and is issued, how much time from that point would they have for the work to start and to continue until it's complete?
The permit's under review. If it gets rejected at the submittal, then we wouldn't consider it as a actual application or filing. But if it is under review and plans are being reviewed and they just have to name a contractor prior to that permit being issued, we can start that process.
Okay,
10 days is a very tight time. To get all that to happen, and she doesn't even have a meeting set up yet.
I mean, we have the notice of violation speaks that it's 10 days. I'm willing to push it to 10 business days. But if the board sees fit to grant an extension of time, we'd be willing to listen to that extension.
Hey, by looking at the pictures, can you tell anything about stability of the house?
It does not look very stable, and my guess is it would fall into a side yard if it were to collapse. I think I'm willing to go to 20 business days. I don't know if Ted feels that way.
yeah, I would be, Wayne, the one thing in the photos, it's really a localized photo. It's not, we don't really see the whole building. But presumably the department only would have taken photos of an area that was, of concern. So based on that, yeah, I think that 20 business days to, have it inspected, have an engineer apply for the permit. And in that time, it would make sense to start looking for a general contractor to do the work.
Question is that, ma'am, how long do you think you'll be able to get started? Would you be able to get started in the near future to prepare this? Or are you financially able to be able to get that going? Because we can't keep giving days and days and days because it's an imminently dangerous building and it's very concerning to us.
I understand. I'm being honest. I don't know what the cost will be. I am financially somewhat able to try to rectify the problem, but again, I don't know the cost. So if I want to just make one clarification, if at all possible. If I'm hearing everyone correctly, my main goal is to make safe. So at that point, once it's made safe, my permits are on board and it's approved as made safe. At that point, the property can be closed down, correct, to further renovate. Is that correct?
Yes.
Well, once
Okay.
once your contractor starts, he has to start within 10 days of you getting that permit. It just has to be made safe. It doesn't have to be made pretty, doesn't have to be finished inside. It just has to be safe.
That's right.
Then that's all you're required to do.
I think I would be able to, yes, I feel confident if I'm granted the extended time of 20 days that I could definitely get what I'm understanding that needs to be done.
Okay, and I just want you to understand the other end. If that doesn't happen, and Tom maybe can speak to this, I think they will demolish the house and then you'll have a lien against the property.
Okay.
So that's why I wanted to give you a little more time, because I think it's important to get that make safe permit in place.
I'm good with it, Abe.
All right, Ted?
Yep.
Okay.
Thank you.
Good
So
luck.
the ruling of the board is 20 business days?
20 business days from today's date.
Yes.
And
Okay.
good.
All right, our
And
next, go ahead.
And that's again to
Wait.
I have 20 business days from today's date to acquire a make-safe permit, correct? I just want to make sure I'm making my notes correct.
To have applied for.
Okay, to apply for. I had the word apply. Okay, perfect. Thank you.
Okay,
It
Okay,
must be under review by the plans examiners. So that's what we mean by under review, with the department.
Okay. I understand.
Hey,
yes,
I'm going into the building right now. I'm in the office. I'll be in there. I'll be up ready for the next case. Give me just 2 minutes, all right?
okay, thank you.
Thank you.
All right, you want to stop recording till Wayne's on board?
Can I have the names of anybody going to testify?
Sure, my name is Adam Ehrlich. I am
All
a
right,
member of Mentor Properties LLC, the owner of the property.
Okay, Adam, are you a lawyer?
Well, for some reason, the city also sent the violations in my name in addition to the company. So one of the first issues is you have a member to this case, which the city has listed, which is not in fact an owner of the property. And my first request is that Adam Ehrlich, first of all, not only did they manually add me, they sent a final violation first and then an initial afterwards. And they also, while they're manually entering my name, misspelled my name grossly. So, you know, it's unclear why someone would manually enter a misspelled name. But being that I apparently am also named, I assume that I would be able to go and speak here. Unless you want to go and remove me as a defendant, as I'm not actually the owner of the property in question.
Okay, hold on. Because all that other stuff, that doesn't mean anything to me right at this particular moment. What I want to know, are you going to be testifying in this case? Are you a lawyer?
I am not a lawyer.
Okay, then if you're going to be testifying, please raise your right hand. Swear to tell the truth, the whole truth, nothing but the truth. Please respond.
I so affirm.
Okay, who else is with you and who are they going to be testifying?
Sure. Bill Baker is
William
on.
Baker.
Sorry.
Hey, Bill Baker. Bill, can we
Baker,
see a
yes,
picture
sir.
of you?
I do not have that right now. I'm driving. It's on an audio call.
Okay. All right. Could you please raise your right hand, swear to tell the truth, nothing but the truth?
Yes, I do.
Okay. Is there anyone else?
Not at this time.
Nobody else is going to be
Chairman,
testifying,
so-
just you 2 guys, right?
L and I will be also testifying.
Correct.
Oh, yeah, I know, Tom. I got that. All right.
Excuse me, Mr. Chair, can I just ask, so, well, just to clarify, Mr. Ehrlich is a member of the entity that owns the property, is that correct?
That is correct.
Okay, and what is Mr. Baker's relationship to the property?
He is the structural engineer working to make the property safe.
Okay, thank you.
Okay. All right. All right, so we got that squared away. Let's get started. I'm Wayne Miller, board member.
Amy Rivera, board member.
Ed August, board member.
Philip Motto, Boards Administration.
Jace Correa, Department of License and Inspections.
Thomas Rybakowski, City of Philadelphia, License and Inspections.
Tom, hold it right there. Could you please raise your right hand, swear to tell the truth, nothing but the truth?
Yes.
Okay, go ahead.
If need be, we may be also calling Inspector Trainer from L&I as well.
Is Inspector Trainer here?
He is.
Okay, Inspector Trainer, please raise your right hand. Swear to tell the truth, nothing but the truth. Respond.
You're muted.
I do. You do? Okay, good. All right, let's continue with the rest. Go ahead. Has everybody stated their name with L&I and all? Okay. Phil, can you read that into the record, please?
Yes, sir. This is MI 2024-004-703 for the property located at 430 through 434 North 62nd Street. Adam Ehrlich is the appellant. He's present in the room.
Okay. Tom, you want to start this out?
So essentially, we have a property at 430 through 434 North 62nd Street that was originally declared as unsafe by the department in June of 2023. Following an inspection that took place in May of this year, May 31st of 2024, the property was declared as eminently dangerous as the property continued to deteriorate. And then notices were sent via mailing and also posting of the property, and that's what brings us to today's proceedings. In hearing the case, you're going to hear that the applicant or the appellant has had notice of the violations approximately 30 days ago, where communications were via email, and that a appeal to this appeals board was filed. In the meantime, that email was dated June 26th of 2024, where it was sent by a Connor Rogers, who made reference that they were a real estate agent and a agent for the property, and that they were working with an engineer to ascertain a permit. I will share my screen and show photos of the property at the time it was inspected. It was inspected by Inspector Trainer, who is present today. We will also ascertain at the end of the statement in that the owner or the owner's LLC knows that the property is in violation. We have communications from the department approximately 30 days ago. Tomorrow, it will be 30 days that a permit would need to be required, and that they have been working on getting that permit. And I'm assuming, since Mr. Baker is present for today's proceedings, that they will be able to ascertain that permit through a design professional's engineering report. So with that said, we would be asking for a permit to be under review within 30 days for the repair of this property. In the interest of time, I'll share my screen. So these are the photographs that were taken. This is a photograph of the property at 430 through 34 North 62nd Street. You can see that this property is heavily covered with overgrowth.
I don't recognize those first photos from what angle or whatever that would be there.
That photo was from the rear of the buildings. James Trainer from Licenses and Inspections.
This is a photograph of the property. On the left, you can see that this is the property at 430 through 34 North 62nd Street. It is the one with the porch or the overgrowth that has taken root throughout the frontage of the property. And then the right-hand photo shows a zoomed up photograph. These photographs do have Inspector Trainer's timestamp and date mark for the case that's in reference to the property. There's two other photographs of the property. You can see that the front of the property at the porch has suffered a partial collapse, where you can see that the roof is starting to fail. I would bring your attention to one of the other photographs that Inspector Trainer took, is that the neighboring property does appear to be occupied.
Can we get Mr. Trainer sworn in?
He was already sworn in, Amy.
Oh, I'm sorry, I missed that.
Pictures of trees.
The next photograph is taken of the front of the property with the posting on the front. And then you have again of the front of the property with the immense amount of overgrowth that has taken root over the structure and over the front porch. There was also a notice of demolition that was posted to the property. That posting was June 14th of 2024 with a notice. That's also what brought us to today's proceedings. And then there is a further part of a more expanded photograph showing the front of the property of 430 through 34 North 62nd Street. And as represented to the board, the department would be asking for a permit to be under review for the repair of this property to make the property safe within 30 days. With that, we rest.
Okay. Adam, can you tell us your part of the story?
Yeah, absolutely. First of all, the majority of the photos which were shown are close-ups of trees or bushes. And I mean, going and doing a close-up photo right in front of a big bush and showing that there is trees and bushes in front doesn't in itself make any sort of structural violation. That's, if anything else, we're talking about high weed, something which would never be in itself an imminently dangerous situation. We were unaware of the initial violation and have, would say that we'd never gotten service for what was claimed to be given in 2023. However, as part of our,
I object to that, sir. You were under, or your entity, your LLC was actually served court paperwork, and there was a court proceeding under the unsafe case, and that is docketed.
If you have any, cards that go and show service for these things that service did, I would be happy to go and see them. I will go and say that the violations, when we went by the property, just part of our normal inspections and routines, had noticed that the front porch had a defect in it, and went at that point, this is about maybe a week or two prior to anything posted or any of these photos here, went, confirmed the property was secured, the property was open, and when we saw that, enlisted the work of a contractor, Connor Rogers, who we mentioned, for help with assisting on this. With that, he had recommended the structural engineer, who we were going just to go and take care of the front porch, where at that time, I believe the understanding was, as all the violations were pertaining to a hole in the front porch roof and nothing to the building itself, the debate was whether or not removing the front porch roof or fixing it would be the better course of action. However, when the inspectors when the contractors went to take a look at the property after this, they were the ones who first noticed that the red imminent dangerous stickers had been put on, and informed us this. So this was maybe a week or so after we had been there. Also went and said, we know that we had left the building fully secured, and this building has been secured for years without any instances that the front door was kicked in. When we got these new violations, they specifically just stated entire structure is going to collapse, which, based that the only violations prior to this had to do with the front porch, we were confused as to what about the entire structure, what is it that would need to be fixed beyond the front porch, and which is one of the things that in discussions with the contractor and the structural engineers on here, try to get that clarification. So when you go onto the city website, it just gives you a general, summary of a violation, but it's not until you get the actual paper violations that go and tell you the specifics that need to be done. So after receiving notice that this imminently dangerous had been posted, we were very closely watching all of our mail, seeing if we would go and get a notice of this violation, any of the specific details. Nothing was sent. They made reference to an email being sent, but as was mentioned, I'm not a lawyer. Sending an email is not in itself notification of a violation. You have to go and send hard copy violations, of which nothing was sent. So when we saw, still not having received any violations, but having seen a notice posted on the door, we went online and saw the general header of the issues and filed our appeal. Subsequently, after that, a new violation was apparently sent, but they added it to me personally, not an owner of the case, except for they, instead of spelling my name EHRLICH, they spelled it something starting with the U. I think URLIC, not sure, whatever it was, wasn't necessarily me, but they went and they sent me a final violation notice that was dated. I have to go and check the specific date, but after that, we got an initial violation, which was dated a day after the alleged final violation was sent. So not only were we not sending any violations, apparently, when speaking to a lawyer who doesn't represent this company,
I object. Hearsay.
Okay, go ahead.
Okay, well, I mean, they went and they said they submitted emails. So the question is, if they went and saying their only notice to me is sending me an email notification after the fact, I would say that in itself would not ascertain any sort of notice. Not only that, the front door, which was kicked in, was not like that ahead of time, which makes me wonder. I want to ask
Hold it,
L&I
hold it,
if
hold it,
they,
hold it. You're saying that L&I kicked your front door in?
this is what I want to ask
No,
L&I.
yes or
because
no? Are you saying L&I kicked your door in?
the door was sealed when they were there, and 2 days later, when we went by, it was open without any other explanation. Being that L&I stays there on the scene, I would ask L&I, did they enter the property? Did they go in?
No,
And if
are you saying that they kicked the door in?
I'm saying the door was kicked in, and the only people
Do
I
you
know
know who by? Did you see anybody?
who was there,
Did you see anybody kick the door in?
we saw that in the photos, which they have there, the
Did you
photos
see
show.
anybody kick the door in? You're making accusations that L&I kicked your door in.
I
That's a
am
serious problem. If that's the case, I'll take care of it. Show me. Tell me who
What
did it.
what I am asking, what I would like to ask the board is to ask L&I if they entered the property at all. Because in the photo that they showed in the notice shows that they went and had a secured door which was broken in, which a day or two later, this was an issue we hadn't had in years. So my question is, when they went and said that there is a violation for the entire structure, in the details we saw, the only thing it said was structure collapsing. However, when we try to get a make safe to fix whatever the alleged issues are, there are no nothing specified as to what needs to be fixed. If they never entered the property, we're assuming that the only basis that they're saying that the structure is an entire whatever of collapse is solely based on an exterior inspection, in which case high weeds themselves is not a structural condition, and the violation for the front porch, which had been unsafe, nothing had changed from that. So when I appealed that and they added an entire eminently dangerous entire structure, the question is, what additional from when it was unsafe, what are the additional violations that would need to be fixed? What are the specific conditions? Because they don't specify, if we're supposed to fix entire structure collapsing, but they don't say where there are any instances of the roof needs to be fixed inside, there's something wrong with the floor.
Adam, what did the June of 23, when you got that information in June of 23, what did it say?
Well, we didn't, when we got it.
What did it say?
The original, it said it says structure is collapsing was the only thing.
Okay, so you got the information in there from June of 23. It's July of 24.
Well, we didn't get no.
Let me finish.
Yeah.
Okay. Did you do anything to take care of the original issue?
The original issue, yes. The contractor which we had, which found this was prior to us even being aware that there was an imminently dangerous. We had contractors there to work on the issue of the front porch.
When was that? When was that?
That was, we had been to the property about 2 weeks prior to there being anything posted, maybe a week.
2 weeks prior to June of 2003?
No, this violation was put in 2024.
Okay, well, the violation you got June of 23, what did you do with that? What did you do with that violation and how did you address it?
Sure, we were unaware that there was a specific violation out there. Our going and doing work was work we were doing on our own accord based on our just normal, review of the property, seeing that there was an issue. And it wasn't until this imminently dangerous notice went and popped up.
So you didn't get that thing in June of 2023 that there was something wrong. You didn't get that violation.
To the best of my knowledge, I am unaware that we received notice about them trying to go and put their property to sheriff's sale.
Okay.
I noticed we have that.
Okay, all right, you don't have that. You didn't get the violation. Tom, do you have that violation?
I do.
Can I hear it?
Well, I want to see proof of service, not just that they want to have.
But we're not here for that. That appeal.
No.
Never.
Well, we can't appeal if we don't have service. How are we supposed to appeal it?
Hey, Wayne, can I just cut in for a second here?
Sure, go ahead.
Right, and Tom, I obviously want to hear what you have to say. At this point, I mean, our concern here is that there's a building which has been determined correctly or incorrectly to be imminently dangerous. Everything that you're going on about in the history of this
That don't mean nothing.
not be relevant, but it is not our primary concern right now.
The imminent danger.
Could whoever has something on in the background, turn off their the sound, because we got some back talking. Everybody just put their phones on hold or whatever.
So the imminently dangerous
excuse me.
violation, which they went and
Hey,
sent
Mr.
after.
Ehrlich.
Hold on, Adam.
Mr.
Go ahead,
Ehrlich.
Ted.
Jesus
Okay.
Christ. You like to hear yourself talk, clearly, but hold off for a little bit. Right now, we're trying to determine the condition of this. You've engaged Mr. Baker, presumably, as a structural engineer. However we got to the point of looking at this, he has presumably, on your behalf, looked at the building and has determined whether this building is imminently dangerous or not, in his opinion, as a structural engineer authorized by the city to make that determination. So I'd like to hear from him what he feels the condition of the building is at this point. And depending on what he has to say, we will either accept his comments or refute them between Mr. Rybakowski and Mr. Trainer, and we'll make a determination. But all of the history of whether you were served or not, you've had plenty of opportunity to know that there's an issue with this building and to address it. And you're basically obfuscating the real concerns here. And I hope you can simply help us get to the heart of this and determine what to do to go forward. Because obviously something needs to be done. Otherwise, there's going to be determination that this building is going to be demolished in very short order.
Go ahead, Adam.
Sure. Ted, are you from LNI? I'm sorry, I don't know.
Well, if you listened at the beginning, I'm one of the board members. Okay. I am one of the 3 board members present from the Board of Building Standards.
Okay, thank you very much for clarifying.
Yes. So we'd like to hear from Mr. Baker what his opinion is. Has he visited the property? What's his opinion of the condition of the property?
So, and before he starts, can I say 2 things quickly?
I'm asking Mr. Baker. I'm not asking you to talk anymore.
We would want to be clear what the imminently dangerous violations are, which is part of the issue of responding, is that there was no details as far as what about the building beyond just the front porch, if there's anything else that needs to be addressed, which is one of the reasons why we're here, is that this, it was deemed that the front porch, if that was unsafe and was specifically labeled as the front porch, now it's not just the front porch, it says the entire structure. But it is unclear from anything that was sent what are the violations that made it go from unsafe to imminently dangerous that do not apply specifically to the hole in the front porch. Are there any other violations? Was there an internal inspection? Were there other things, because the report solely says structure's collapsing, but it doesn't say where, doesn't say how, doesn't say what needs to be fixed. It's, so if we go and we fix everything and they say, oh, well, we were referring to something else, which wasn't clearly stated, we weren't aware of. So we just want to know from LNI specifically what it is. And just so for when we have the Make Safe report, we need to make clear and understand what exactly the violations that need to be fixed.
Okay. Tom?
And is Mr. Baker still on the call, by the way? I don't see him here.
Mr. Baker dropped off the call.
Okay. Tom, can you tell us what the imminently danger issue is?
As Inspector Trainer was the inspector that issued the violation for the amount of the structural defects, I do know that the porch itself is continuing to deteriorate and the structure itself is impacted by the heavy overgrowth that the interior, we were not able to ascertain the structural ability of the entire interior of the property. It was an exterior inspection that was performed by the department, but the amount of overgrowth that's over this property leads to the designation of unsafe and then the designation of the eminently dangerous. And
okay, I have the violation notice here. It says the department inspected subject structure, determined it is imminently dangerous of collapse. You must repair or demolish said structure immediately. When there is an imminent danger or failure to, or collapse of a structure or any part thereof which endangers life, or when the structure or part of the structure has fallen and life is endangered by the occupation of the structure, the code official is authorized and empowered to order and require the occupants to vacate the same forthwith in accordance with the with the ceased. Conditions in violation: entire structure collapsing due to neglect and overgrown vegetation, causing a dangerous situation to attached neighbor. Location: entire structure. Another part of the violation is operation provisions set forth in the administration code. It shall be unlawful for any person to enter such a structure except for the purpose of making required repairs or demolizing the structure. The following condition shall be: structure collapsing, determined unsafe, and shall be repaired or replaced completely with the International Building Code or International Existing Building Code as required for existing building. Structural members have evidence of deterioration and other are not capable of safely supporting all normal loads and load effects. Adam, do you have that?
That's the code, but it doesn't specify what it is that needs to be repaired. From this, one would gather, they said that they've never gone in the property.
Adam, I have one question. Do you have that violation?
That violation was sent about 2.5 weeks after the posting, because they did not send the initial violation, and it's only after we appealed it that violations were issued around a week or so later, and in my name personally. We did not receive violations in the mail until after the point we'd done the appeal, based on seeing the sticker on the front door.
Okay.
Nothing was sent prior to that.
But one other thing.
Yeah.
The violation in June of 23, you just ignored.
No, we are unaware.
Or no, I don't want a whole dissertation. You ignored that. Am I right?
You are not right.
I'm not right. So why didn't you take care of it then?
Because we are unaware of the situation of that and had people coming to fix it, but not based on the violation.
So you're unaware of it, but you had somebody coming to fix it. Stop it, okay?
No, we went by I went by the property 2 weeks prior because I was in the area. We were doing inspection of the properties. At that point, when I went and saw that there was an issue, and maybe the issue, if it had gotten worse or something, whatever we saw there, wanted us to go and get a contractor to go and show up.
We're going to make a determination. Does Mr. Baker want to talk and tell us what he sees?
Bill, you're on the phone. Well, did you say he got disconnected?
Or
he was not disconnected by us. He dropped off the call and he's not yet rejoined the waiting room.
Imagine that.
I'm not. I mean, we're in different locations, so I know all I know is that he was on. I've been speaking to you. I haven't been speaking to him.
Simple question with regard to Mr. Baker. Has he been given the imminently dangerous citation to review?
He received copies of that. He's been to the property. He's done his inspection. He was here to go and talk about that. He wanted clarification though with the make safe because of, with the front porch that was there. The question is, if there's no evidence that if there are weeds there, that the weeds are doing anything to infiltrate the brick, etc. So the question,
all that stuff, okay? Just get to the point.
We have to.
Right. So the question is, does us going and removing the high weeds and the vegetation, being that
Adam, our question
does he have a report out? Can he tell us what is in his report?
Your structural engineer can understand this imminently dangerous citation. You may be confused by the language.
Oh, everybody involved was confused because there was lack specification.
God, I'm one of the most easygoing people in the world.
Me too.
Very hard to believe. Okay, I'm not the one who has a case before this board. You are. Right now, we've simply asked you if your structural engineer has to make a determination. He has to write a report based on this. It doesn't matter what happened before. He has to write a report and either accepting and stating what has to be done in order to make this to pull a make safe permit or refuting it. And he's got to do that by the end of the day today, as far as I'm concerned. Otherwise, Tom, you can move ahead with this, and we'll talk about that ourselves. You're talking, but you're on mute evidently. So
I would suggest.
Sorry about that. Well, you'd already said that there'd be 30 days. The question is what he wants to
No,
do.
a recommendation of
That's
30
what
days.
Tom said.
We
We
haven't
don't
made
make them
a
decisions.
recommendation
The
yet.
board makes them decisions.
I
So go ahead.
misunderstood. So, I mean, one other question is, why is Adam Ehrlich misspelled listed as a defendant on the, no, because I'm just saying is if there are any fines or penalties, the city is making the attempt to hold me personally
Okay,
liable.
we got that. We understand. We haven't
So
noted that they spelled your
Can we
name wrong.
can we have the board remove Adam Ehrlich, not an owner of the property, as a member of this case, being that there's no standing to list Adam Ehrlich as a defendant?
We received it and we got it noted and we know of your complaint. We'll look at it later. Now, the issue is Mr. Baker there to give us the information, what he has at the building, because here's the thing. This board, we're not inspectors. When we get a complaint, it's either as unsafe condition or it's imminently dangerous. And let me tell you something, and I want you to listen carefully to this.
Listening carefully.
Okay, on our watch, mine, Amy, and Ted, we're gonna not let a building collapse, whatever. It ain't gonna happen. So you have to have you got an imminently dangerous violation now. You have 10 days to have a report from your engineer and then pull a permit to make safe. If that is not done, that building will come down. So let's get the ball rolling. That's it. So if you can show us that your engineer is saying that it's not imminently dangerous or unsafe, give us that report. If it is, then you have to take the proper steps of pulling a permit to get things going. You have, read my lips, you have 10 days, because we're not going to have someone hurt because it is squabbling back and forth. We're the board. We rule on two things: unsafe or imminently dangerous, and we have a policy. And we will not change that policy for God Almighty. Okay? So let's get this done. Is Mr. Baker there?
If you would like me to try to call him on the phone and see if he got disconnected or what happened, he was disconnected, but from a remote location.
Okay. The thing is, we're going to be here for a while. All right? Not maybe with you. You can have Mr. Baker call back. And if not, if he don't let us, we don't hear from him by the end of the day, it goes into effect that it is imminently dangerous, and 10 days it will be torn down if a permit's not secured. And that's the end of the story. So get a hold of him. We'll be here. You get back on and with Mr. Baker to tell his part of the story, and then we'll go. So that's where we're at. Next case.
I will say that after the building was opened by unknown people, apparently I was told that a squatter had gone inside, and we need to go and make sure that that's not a safety issue and that we can go and get him removed to be whatever. So, yeah, I mean, that's something which I think is a result of the city's actions, that we now are dealing with that additional situation as well.
Well, you don't know that, so stop making them.
Oh, we know that somebody was seen in.
Prove it. I don't want people saying something that they can't prove. This is the end we're in today. No. And you come when you have stuff today. All right, let's move on. Next case.
Whatever you just said didn't come through the speaker, but I'm sure it was very motivating.
Yes, it was. All right, let's move on. Get a hold of Mr. Baker and come back. Call Phil or Debbie. We'll get you back on the hearing. But
will that affect the timeline if he gets on?
10 days.
Will that affect the timeline if he comes on and speaks to you?
It don't affect any time. It could if he gives us an engineer's report.
Okay.
Okay. So let's go.
Thank you, Mr. Miller.
You're welcome.
Thank you, board.
Okay. Okey
Will I
dokey.
receive a written notice of this hearing in the mail?
You'll get what you're entitled to, whatever written notice has, you'll get it in the mail. And if Mr. Baker doesn't come back today, here's what it is, and I'm telling you, you can bank on this. If we don't hear from Mr. Baker within 10 days, that building, or if you don't have a permit, that building will be down. And
Wait,
that's
so
the
he
end of
can
the
he can
story.
get on the Zoom. If he can't get on today, he can get on the Zoom tomorrow?
No,
You saying?
today.
He says 10 days to get in touch with you?
Today,
Okay, I'm
today.
sorry. You said if he didn't get in touch with you in 10 days. I misunderstood what you said.
But I said, if he don't get in touch with us, the ruling that we will make with this board is you have 10 days to get a permit or the building's coming down. I don't want anything misunderstood.
Okay,
It will come down. Tom Rodakowski, are you there?
I am.
If we don't have the information in 10 days, that building comes down.
So it's either an engineering report or a permit issued within 10 days.
Correct.
Or we can do a line of enforcement.
No,
Understandable.
we will.
well, I also want to make sure that if we submit it, that they don't hold off on approving it just to go and extend that 10 days. So if we,
They don't need to be talked to.
Wayne, we can't hear you, Wayne.
we can't hear any of the yelling, unfortunately.
Within, Wayne, within 10 days, a make safe report or make safe
Talk about
permit has
people
to be
walking away. Yeah, but it's
obtained. The make safe permit needs an engineer's report and potentially drawings.
Yeah,
When a building
Did you
is,
get that?
when a building is defined as eminently dangerous by L&I, I am a structural engineer. My charge is to go look at that entire building. If it says the entire building, the charge is to look at that entire building and issue drawings and or a report to make it safe. If I deem it safe without needing anything, then that's what I say. And that accomplishes that task. Mr.
Okay.
Baker knows all this.
So-
Yeah, Miss Rivera,
Wait,
I
just-
find that very helpful and appreciated because of my lack of experience with this. My understanding was, if a structural engineer can go and say, we've looked at it and we don't believe it's unsafe, and
What's the
that's
letter?
acceptable without having to know specifically what the city says is unsafe. If they're looking at what they're looking at and saying, okay, we fixed the porch and that should take care of everything. Our question was, since it said the entire structure, but there was nothing cited beyond weeds in the front porch, if there was anything else that needed to be addressed. That was the only question which I had. But if it's up to the structural engineer to determine, which is what I'm hearing you say, then I will,
Yes.
I guess that clarification isn't necessary. I thought that it would be necessary to make sure that we addressed all of the concerns of L&I, and what we were just in clear to, just saying the building's unsafe without saying what it is we should be looking at or focusing on. That was where the lack of clarity was, because we wanted to make
told
sure
you
that we didn't say we
entire
fixed the front porch
structure.
and they said, oh, we had a problem with the back door. And
Adam,
didn't know.
listen to what Amy's saying.
It tells you the entire structure. That amount of overgrowth alarmed me. You can't even see the building from the street from Google that I looked at it. I believe that there are going to be walls that are bearing walls that are leaning that are no longer safe. All of that needs to get addressed. Mr. Baker will understand that. We need to-
that's why we hire a professional to have here, because
Okay.
when it comes to those structural issues, that's his specialty and not mine. And so
Okay, get his specialty
I'm
and get him
very
back here
disappointed that
today.
he's not here right now. I don't know, and I apologize on, I guess, my and his behalf for. He was on his phone. I don't know if his phone. I don't know, and I don't want to.
Get in contact with him.
He can call in before the end of our meeting, before 4 o'clock.
Before 4 o'clock?
Guys, let's be simple about this, okay? To be clear, he needs to inspect the entire building. It's not up what you tell him to look at or whatever. The entire building needs to be looked at. and he
Right,
needs-
it's in the violation.
Hang on one second, Wayne. He needs to file a report. I don't think we need to have him call in today. At this point, we have 10 days to apply for a make safe permit, or file a report saying that it's, is not required, whatever his determination as a professional, that can be done. We don't need to hear any more from you guys today.
Okay. All right.
Can I just
Okay, good deal.
can I just clarify something for the record? When you say 10 days to obtain the permit or get an engineering report submitted, do you mean 10 business days or 10 calendar days?
10 calendar days to have a make safe permit. And that would need an engineer's report to get the make safe.
Okay.
Can I make the request that it be 10 business days just to go and allow him to get up to speed, being that he was not party to this conversation?
It's 10
for whatever
calendar
reason?
days. We have to be consistent. It's 10 calendar days. That's
Okay,
what
and
we
then
give everybody else to
day
do,
one
okay?
would be tomorrow? So tomorrow would be day one?
That's fine, yes.
Mhm.
Okay.
Yep. Okay.
Thank you very
good
much.
deal.
So should I still have him call, should I still have him call in?
I don't see the point.
I don't see the
No,
point.
just, you got the, you know what you have to do. You got 10 days to get a permit to make safe. And if he has an engineer report saying it's safe, then
And submitting for the permit, even if the city doesn't approve it, as long as it's submitted within the 10 days, that is sufficient.
yes,
Right.
and when you get the permit, when you get the permit, you have to continue work until it's completely finished.
Okay, also for the record, this property has also been listed for sale. We have a business owner on the block who has expressed interest in also purchasing, fixing, what have you. So just to let you know, we are taking efforts beyond just the repair, also to go and have action.
But
on
right
this
now,
property.
Adam, we're dealing with you. We're not dealing with the sale. We're dealing with you.
Well,
Okay, and
Mentor
and-
Properties LLC, but yes.
Whatever. Okay, whatever it is. All right, good deal. Thank you.
Thank you very
All right.
much, your honors, your board
No, I'm
member.
not an honor. I'm not an honor.
Okay, well, it's
We don't
been an
have kings and
honor.
honors in this country. Okay.
Fair enough.
All right, fine. I also want to say to our lawyer. I do, and it's for the public record. I do not stand for someone making accusations against people that are working that they did something wrong. Now, I want to ask you a question. The next time, can I throw them right off the docket? I'm asking you a question. Because
Are you
I ain't
asking-
gonna put up with that nonsense. I'm not putting up with it anymore. Accusations, backdoor things, I don't like that. And I don't care who it is,
No,
okay?
I understand, and that is something that I would like to discuss with the law department because
Okay, well,
it is a
discuss it
concern.
with them, please.
Yes,
Because
because
I don't like
I feel
it.
if those accusations are being made against the city, I feel like an attorney representing the city should be present to
Okay,
handle the
okay.
situation.
Fine. All right. That's it. Let's get to the next case.
Do we want to go back and see if anyone for 115 Seymour Street or 115 North Grove Street is
I
present?
think that's a good idea, Amy.
Yeah, because I have another jurisdiction to jump into.
With your permission, let me inquire, Mr. Miller?
Sure.
Is there anyone here that represents the interests of 115 Seymour Street? Zafar Abdur Rashid. No one has answered for the property at 115 Seymour Street.
Okay.
We have 115 North Gross Street.
Phil, could you excuse me for a second?
Yes, sir.
The time now is almost 2:30. The individual from 115 Seymour Street was supposed to be here at 1 o'clock. He's not here. Do we do the case now and make our decision without him here?
I would ask that both of these, since they are unsafe and eminently dangerous, that both be ruled to be city affirmed failure to appear, or so denied failure to appear.
Okay, both Seymour Street and Grove Street?
Yes.
Let's take them one at a time because we just called Seymour. So let's put Seymour on the record and render your decision.
Okay, all right. What we'll go, there's nobody, actually, no one's here from Seymour Street. It is 2:25. He was scheduled for 1 o'clock. That's an hour and 25 minutes that he is past his time. So what we're going to do, we're going to go through with it. My name's Wayne Miller, board member.
Amy Rivera, board member.
Ted August, board member.
Philip Mata, Boards Administration.
Jace Korea, Department of License Inspections.
Okay, if that's everybody, Phil, could you read that into the record?
Yes, sir. This is MI 2024-004638 for the property located at 115 Seymour Street. The appellant was Zafar Abdur Rashid.
Okay,
There's been no
Tom
answer in the room.
Tom Rokowski, could you please raise your right hand? Swear to tell the truth, the whole truth, nothing but the truth?
I do.
Can you tell us something about this project?
This property was deemed unsafe for conditions of the front porch, structural damage. As the appellant is not here, it is my representation to the board that it should be denied failure to appear.
Tom, is this project, I mean, is this, property, is it inherently dangerous?
It was declared as unsafe, sir.
Okay, it's clear of unsafe,
Yeah.
and so we will give, 30 days to get a permit and continue work.
The applicant was here at 1 o'clock. I don't know why they left the room.
Well, I can see why they were left the room because that other case took
appears-
so long.
It
Okay,
appears that the owner may be deceased. I'd like to give him 60 days. I've at least looked at Google pictures and I can see what's
Okay.
wrong with the front porch roof. I just
Ted,
don't know.
are you
if anyone's
okay with
gonna-
that?
Yeah, I'm okay with that.
Okay, I'm okay with it, Amy. All right,
Okay.
60 days. If we can contact the individual to get a permit within 60 days and to make safe.
All right, we're gonna
Okay.
say 60 days to obtain a make safe.
Yes,
Thank you.
okay, that is 115 Seymour Street, all right? Next one is 115 North Grove Street. Is 115 North Grove Street, anybody here? Is anybody here from North Grove Street? Okay, what we'll do is we'll do the same as we did to the last case. My name's Wayne Miller, board member.
Amy Rivera, board member.
Ted August, board member.
Philip Motto, Boards Administration.
Jace Korea, Department of License Inspections.
Thomas Rybakowski, City of Philadelphia, License and Inspections.
Okay, Tom, raise your right hand, swear to tell the truth, nothing but the truth?
Yes.
Okay, Phil, could you read that into the record, please?
Yes, sir. This is MI 2024-004697 for the property located at 115 North Grove Street. The appellant is Debbie. Last name is Speight. There's been no
Okay.
answer from the appellant in the room, sir.
Okay, Tom, could you give us a little bit about this case?
The property at 115 North Grove Street has been declared eminently dangerous by the department. Per the appellant's filing, the appeal information or statement is, I tried to contact the owner, but have not heard from him. I am the tenant. Per the statute, the property deemed eminently dangerous as being a tenant, they do not have standing to disagree with the designation of the property being eminently dangerous. They do have standing to appeal the notice to vacate the property. As the appellant is not present, I would represent to the board that there is no action by the board.
Can we see the pictures of it at least?
Yeah, can we take a look at it?
Yep.
Thanks, Tom.
Can everybody see my screen?
Not yet. It's coming up now, Tom.
How about now?
Yes, we can.
Okay, so that's the front of the property. And that's the rear. And it's mostly the rear. You can see the rear bay, second story rear addition or rear second story bay. You can see the structural members are sagging and starting to list and collapsing into the common driveway. That's the front of the property. And you can see that somebody actually peeled the ID sticker off the front of the property. That photograph was taken June 13th of 2024.
And when was the initial violation?
Initial violation was initial notice of violation was dated December 14th of 2023.
Thank you.
And Tom, you say there's no action by the board?
I would say that the appellant only has standing related to vacating the property, not to discussing the designation of the property, as they are not the owner, and them not being present, they do not, there's no action by the board.
So I have a question. Because they are only renters or whatever, they're in there, not the owners. The building is still imminently dangerous. So they could stay there and nobody could do anything to remove them from there to protect them?
No, so what we would do is we would post the property, and then they'd have to get there'd be court action to vacate the property.
That was
Okay.
gonna be my question too. So, Tom, when you're referring to notice to vacate, that is separate and apart from the imminently dangerous violation, correct?
A eminently dangerous posting that was affixed to this property does say that you are ordered to vacate the property. If they do not vacate the property, the department will go the extra step and actually post a notice to vacate the property. And also, if they don't, then we can seek legal action through the Court of Common Pleas to vacate the property as well. Where I was waiting for today's appeal and the ruling of the board, and hoping the appellant would show. They didn't show, and they make a representation that they are a tenant in that property. So with them not appearing, it's my hope that they vacated the property of their own free will, and then we'll take the next steps to deal with the property.
If the
Good.
tenant has received the violations, do we know that they were also sent to an address of the owner?
I have that the notice of violation was mailed to. I have that a notice of violation was mailed to 3 separate addresses for the owner. As some of those addresses might not be public record, I can only say that 3 were mailed to separate addresses.
Okay, you mailed to the last known address that the city has, and you mailed to 3 different addresses. I think that meets the requirement that you did everything under your power.
With that said, I'd like to, I need to get to the next jurisdiction.
Well,
Okay.
and I just want to say if the tenant does not have if the tenant does not have standing, or at least they can't appeal until the notice to vacate is posted, the explicit one, as opposed to the one embedded in the ID notice, then I think the board should dismiss this case. I don't think that they can't really take it. It's been filed. They need to do something with it, but I think the appropriate action would be dismissal if there is a lack of standing.
Okay, we'll dismiss it. Ted, Amy, you good with that?
Yes.
Okay, it's dismissed. All right, Tom?
Thank
have
you.
to go.
With that said, everybody enjoy the weekend.
Excuse
Okay,
me,
Tom,
Tom?
you have somebody filling in for you for the next 2 violation cases? Andrew Miller?
Those 2 were continued 60 days.
Oh, I'm sorry, I didn't know that. Thank you. Okay, 6, good deal. All right, Tom, have a good one, man. I
Thank you.
appreciate it. Hey,
You got
Tom, and I don't, again, you guys do your job, man, and I don't want anybody accusing you of just doing something wrong.
Understandable. Thank you, sir.
Okay, so the next one would be a refusal for 4432 Main Street.
That's correct.
Okay. Okay. Bill, are the people here?
Yes, sir. The appellant is present in the room, Mr. Jerry Rowland.
Okay. Okay. All right.
I'm also present on behalf of JKRP. I'm Marissa Howard.
Okay, bear with me 1 second, please. Okay, here we go. Sorry for the holdup. For 4432 Main Street is, who's gonna be representing that group? Jerry?
Marissa.
I can.
Okay.
I'm Marissa Howard.
Marissa, are you a lawyer?
No, I'm an
Okay,
architect.
so you're gonna be testifying, right?
Yes.
Okay, I have to swear you in. Could you please
Okay.
raise your right hand? Swear to tell the truth, whole truth, nothing but the truth?
Yes.
Okay, Jerry, you gonna be testifying in this too?
Not sure, but sure.
Okay, are you a lawyer, Jerry?
No.
Okay, could you please raise your right hand, swear to tell the truth, the whole truth, nothing but the truth?
I do.
Okay, I'm Wayne Miller, board member.
Amy Rivera, board member.
Ted Ogden, board member.
Philip
John
Motto,
Dimes,
Boards
Fire
Admin-
Code. I'm sorry.
Philip Motto, Boards Administration.
John
Jay
Dimes,
Scoria-
Fire Code.
Sorry, Jay Scoria, Department of License Inspections.
Okay, everybody in? Phil, could you read that into the record, please?
Yes, so this is MI 2024-004-430 for the property located at 4432 Main Street. The appellant is Jerry Roller. He's present in the room today, sir.
Okay, whoever's gonna present the case, go ahead.
Hi. We are seeking an appeal for providing one exit at the second level of a two-story building. It's located on Main Street in Manayunk. Can I share my screen?
You certainly can.
Okay,
Yep.
let me just do that. Sorry. So, can you see our screen?
We see it now.
Okay, great. So this is part of a larger development that will be straddling Venice Island and the canal. So as part of that development, we are building a small two-story commercial and building on Main Street. It's roughly 4,000 square feet in total. There's 2,000 square feet at the second floor. There is a driveway that connects off of Main Street with a new vehicular bridge to provide access to Venice Island. There are two residential buildings on the island. As part of our earlier approvals process with CDR and planning, they had recommended where this access point is shift to align with Carson Street across the street. There was previously, or still is, a bridge that's currently located tight to the east side property line on Main Street. So this is an overall site plan just to get your bearings. We're also working with the city to get approvals on a pedestrian bridge at the second level of the Main Street building that would connect across the canal to the residential buildings that would serve as an exit in a flood event. So I'll take you to the Main Street building. Here at the lower part, you're seeing the ground floor plan. This is a lobby and stair that connects up to the second floor with an elevator shaft. This is that drive-through that goes through to connect to the vehicular bridge. And then on the left side, you're seeing a small retail space and some utility rooms. So at the second level, all that there is the stair, the elevator, a mail room, a leasing office, a bathroom, and a package room. It's really just to serve as an access point for the residents of the island. In a flood event, there is a door here that will connect to a pedestrian bridge, should they need that. And just as general access, if people come in and get their mail here, they can go across the bridge. So.
How wide is that canal?
The canal, I want to say, is 30 feet. I could be wrong on that.
Okay, okay. I'm just
The
curious.
bridge itself is 99 feet from building face to building face. So right now, the upstairs of Main Street is 2,000 square feet, 7 occupants. We are requesting just to only have 1 exit due to the small nature of the building, and that path of travel to the exit at the ground floor is 146 feet. And with a common path of travel for 1 exit that's allowed is 75 feet. So that's what we're asking for, is to extend that.
How many people do you anticipate being on that second floor?
9.
What else?
And where it says mailroom, are they lockers?
It's just mailboxes for 180 units.
Okay. So in theory, everybody in those units has to come to the mailroom on a daily basis.
Correct.
Yeah.
And then there'll be a package room as well for Amazon deliveries. We're not planning any mail or package on the island itself.
And the stair at the first floor, off of the electric on the other side, sorry. Is that just going down to a lower grade at that point, or?
Yes, there's a water room that's located here because we have to get all of the utilities to the building, have to come in through Main Street, and then they go across the underside of the pedestrian bridge. It's a very hard site to get utilities to.
So given that the 7 occupants, 9 occupants total is kind of the calculated load, is there a maximum occupancy that you're willing to post this for? I mean, would you post it for the 9?
I would have no objection to posting it to 9. Jerry, would you?
I'd say 15, not to be not to have somebody complain if there are 10 people getting mail, but I mean it's a small occupancy. It is also sprinklered, so I don't see any hazards here. I mean, let's post it to 15.
And is the underside over the kind of vehicular driveway, is that kind of rated, and how high is that underside above the driveway?
It's 14 feet.
Okay. Do you know, is it currently rated, or is it?
Oh, yes, it'll have a 1-hour rating.
Okay, yeah, and really from the end of the mail room, the beginning of that corridor back to the package room, I mean, the distance from there to the stair is less than the 146. It's still more than 75, but it's
Correct. And that 146 is counting going down the stair and to the front door. So we were right around I think 79 feet, if I remember correctly, to this door here.
From which point? From the package room, or
from the most remote point in the package room?
And that would be a rated door?
Yes.
Okay, where's the entrance to the elevator? Is it within that hallway, or is it out in the big room? On the second floor?
On the second floor, the entrance, it's a 2-side elevator, so you enter on the back side up here.
Okay.
John,
and the LO of 15, are we saying only for the second floor? Because there's retail downstairs. You could have multiple people in the retail.
Yes, I would just ask that the second floor have the occupancy count.
Yeah, I mean, the retail has direct access outside.
But I just wanted to be clear, we were saying at the second floor.
All right. Okay. Anymore, are you guys good with that? Or do you want to caucus?
Do we know what the rating is of the ceiling of the drive-through?
1 hour.
John, any?
Yeah, this
comment?
is fully sprinklered and has smoke detectors, correct?
Correct.
Okay, and then the space itself on the second floor is pretty transient in that people aren't going to be hanging up there. That are going to get their stuff and leave. And then you got the package room in the back. The leasing office may have some people in there, right? You might have, what, 2 people in there max that hang
Yeah.
there for any decent amount of time. You know, I mean, I have an inclination to approve it, but obviously up to you guys.
Yeah. I'm good with it. Amy, Ted?
I'm okay with it, yeah.
All right, so an LO of 15 on the second floor.
Yes.
Okay, I'll stop there.
Okay.
Yeah.
Anything else? All right.
Thank you.
Okay, thanks
Thank
very
you.
much. Good luck. All right.
Thank you. Have a good day.
You too.
Bye-bye.
Okay. Is the person from 6600 Essington Avenue here, Phil?
Yeah, yes, this is Eric Pangle with Camberson Theater Architects.
Hi, Eric. Are you going to be the only one testifying?
I will be, yes.
Okay, nobody else, just you, right?
Peter Theodore is also in the room.
Okay, all right. Eric, are you a lawyer?
I am not.
Okay, could you please raise your right hand, swear to tell the truth, the whole truth, nothing but the truth?
I do.
Okay. Peter, could you please raise your, are you a lawyer, Peter?
I'm an architect.
Okay, that ain't a lawyer.
No, yeah, thank God. Thank God. Yeah.
Peter, could you raise your right hand and swear to tell the truth, the whole truth, nothing but the truth?
I do, thank you.
Okay.
Excuse me,
Mr.
Yeah, can everybody spell
Hold
their
on,
names?
hold on.
Can everybody spell their names for the court reporter?
Yes, ERIC, P as in Paul, ANGLE.
And when you
Okay,
speak,
Peter?
just announce yourselves because we can't see you
Okay.
that well.
And Peter Theodore, it's Peter, P-T-E-R, Theodore, T-H-E-O-D-O-R-E.
Okay. All right, I'm Wayne Miller, board member.
Amy Rivera, board member.
Ted Ogden, board member.
John Dimes, Fire Code.
Philip Motto, Boards Administration.
Jay Scurria, Department of License Inspections. And I also have Jeffrey Tan here. He's the floodplain manager for LNI as well.
Good deal. Phil, could you read that into the record, please?
Yes, sir. This is MI 2024-004713 for the property located at 6800 Essington Avenue. Eric Pangle is the appellant. He's present in the room today, sir.
Okay, whoever's going to present the case, go ahead.
Okay, I'm going to share my screen.
Go ahead, Eric.
All right, it was an existing building built in the 50s, slab on grade. It's going to be a truck service shop. We've gone for Penske truck leasing. The existing building is currently in a floodplain. Our finished floor is just over 3 inches below that floodplain. There's perimeter trench drains and rain gardens that surround the building. What we've done, working with Jason Jeffrey, is we've introduced a dry flood-proof panel system around all the door openings. We've added stairs and ramps to maintain egress when those panels are installed. And we are working through the sump pump requirement per the FEMA ordinance. We've got 4 sump pumps that are battery operated. being proposed. And the question is of what kind of permanent backup power is needed. We're following the detail in the FEMA manual, figure 8. That indicates the sump pump can be tied into a battery or a backup power unit. We are utilizing the battery option, a battery at each pump. And that's the argument of this proposal. We have the calculations for the volume of water that is being generated. We've calculated everything for the seepage. We're just over 6 gallons per minute. So in designing the pump system, we are greatly over designed for what the requirements would be for the size of this facility. If the battery backup to handle the water that'd be infiltrated for the calculations for the size building, we are at 9,245 gallons if we had 21 inches of water up against the building. So we designed it as conservatively as the code required us to do so. Based on the amount of discharge for the water, the pump system on battery backup could last 5 days, and without having the permanent power turned back on. So our request is to allow the battery backup for these sump pumps.
And if I could just jump in real quick. So this is a facility that's going to employ 60 people when it's up and operating. It's Penske Automotive. They are throughout the United States, highly respected. And ironically, using batteries in this application is right up their alley, considering that they'll have multiple batteries on site. The batteries will be monitored and alarmed and checked. And as Eric alluded to, we've gone above and beyond. And I have to, first of all, take a step back and compliment Jace and Jeffrey. We've been working on this for close to how many months?
Yeah, we've been going through this 6 months now. There were the final steps of approval so we can open the facility.
Right. And if I could just comment on Jace and Jeffrey again, because I'm licensed architect throughout the United States, including Florida, so I deal with FEMA and floodplains all along. But dealing with these gentlemen, I learned quite a bit, and we want to do the right thing. And in doing so, again, we're only 3 inches below the floodplain. It's a condition we inherited, but we want to make it correct. We're spending close to $100,000 to add the battens that will raise the elevation from being 3 inches short to 21 inches above. And we also believe that we've put other measures in place, such as getting any equipment off the floor. There's no mechanical equipment, no electrical equipment, nothing that if we had a catastrophic failure and everything stopped working, we've mitigated that situation by taking everything off the floor and reducing that liability. So with that, you can see on the screen right now the measures that we're going to ensure that the water doesn't ever breach that flood. And I think that we've been at it a long time, and the only sad part about this story is that we've got employees ready to go and start working in this facility, and we're sort of dormant. So we're hoping today that you'll look at our argument and agree with us and find our solution to be adequate and allow us to move forward. And that's all I have to say. So thank you.
Sure, you're welcome. Jeffrey, Jace, can you give us a little on this, please?
Yeah, I can try to walk this through. The provisions around the sump pump requirements are coming out of the reference standard, the ASC 24 standard, when it coincides with dry flood proofing installations under Chapter 6. The purpose of those sump pumps is to help deal with any, incidental seepage that comes through with these flood panel installations, and any areas where you can't predict permeability into the building exterior. So the intent around dry floodproofing is to make sure that most of the building is impermeable, but there are just going to be those unpredictable factors that come when you just can't tell like the condition of the building. And that those sump pumps are intended to deal with that seepage to mitigate any flood risk loss. So the intent there is not about safety of like public safety of life, but is to reduce the overall property damage on the site. And so I think and with regard to this emergency power piece, the reference for that comes from the commentary of the ASC standard, especially when you're dealing with a flood emergency situation. You never know what could happen to the critical utilities around the site. So that's what's built in. So that's just to help give you some background there about what's going on with this provision.
So are you okay with what the steps that they took to protect everything?
It seems to be in line as the appellants have shown from the FEMA technical bulletin standard that battery backup should suffice. The only other thing I'll say to the board is to follow the guidance of the building code with regards to the criteria of whether or not the variance meets the minimum standards. And I can send over a link to the to those criterias that are established in our flood protection variance form.
I mean, is the main issue that the battery backup will only last 5 days?
It's just, I think it's just about whether or not the battery backup falls within the building code standards of what emergency power is. So that's kind of the design implications there.
Yeah, the situation with them right now is this is an existing building. It's not new construction. So usually, you know, if it was new construction or if it was a high rise, you deal with emergency power. But because they inherited the building, they don't have that option. So this is a pretty unique situation.
The question, if their slab were 3 inches higher, would they have to do nothing?
Correct.
Correct.
Wow.
Yeah, it's been an expensive endeavor, and the improvements of the property, we exceeded the threshold that triggered all these requirements.
And to be fair to Jason Jeffrey, I mean, they are following the letter of the law. And I was telling my guys today, I have an air conditioning unit in Florida that's was an inch. They changed the floodplains. The floodplains are always moving around. That was an inch too low, and I had to add rails. So to be fair to them, they are adhering to the letter of the law. But that's why I kind of said to you, we took, just to go one step further, we took anything off the floor so that if it got damaged, you know, you can't claim it on your insurance because you'd be in violation. So we made sure that we removed anything. And I'm going to throw something else at you. The funny part about the floodplain insurance is that you're capped out at a very low amount, so that the $100,000 we're spending right now to mitigate the floodplain insurance would hardly even cover a fraction of the cost that the insurance company would give us if something was damaged. And that's just sort of a backstory because it's kind of screwed up the way it works with FEMA. But to summarize everything, like I said, if this weren't an auto dealership, batteries might be considered iffy, but this is an auto dealership. They are going to monitor it, and they are in the business of selling batteries. And batteries are commonly used in house sump pumps and other commercial buildings as well, especially where you don't have gas or electricity in rural areas. So we've used this system in other applications, and it's never been an issue. And I'm further comforted by the fact that it is Penske Automotive. That's a global billion-dollar enterprise. So. Again, thanks, Jeff and Jace.
I'm okay with
Hey,
it.
You're good with it, Aim?
Yeah.
Okay, Ted,
Yep, I'm good.
so am I. Good luck.
Thank you, guys.
All right, thank you.
Appreciate all your help. That was easy.